My name is Karen Winston. I'm an immigration attorney in Jacksonville, Florida, with the Law Office of Karen Winston, where we focus only on immigration law. We handle all types of immigration law cases. We do deportation defense, family-based petitions, and humanitarian forms of relief. I'm really fortunate that I am somebody who can say that they genuinely love their profession and love to get the work that they do. Every day I am happy to come to the office. I am grateful for the opportunity to make a difference in people's lives and to be a part of something as important as their immigration process. Today, I'm just going to talk to you about the Fiance visa, what the requirements are generally, and an overview of the process. We love doing Fiance visas in this office. We've represented people from all over the world. We've had fiancés from Ethiopia, Myanmar, Colombia, Guatemala, El Salvador, the United Kingdom, Australia, South Africa, Japan, and many, many other countries from around the world. One of the main things that you have to show is that you intend to marry each other within 90 days of your fiance arriving to the United States. So you've got to prove to immigration that this is your true intention, okay? We usually meet that requirement by giving a statement from the beneficiary and the petitioner. In this case, the beneficiary is the fiance who is abroad, okay, and the petitioner is the U.S. citizen who's petitioning for the beneficiary to come to the United States and join them so that they can get married. One important thing to note is for the petitioner, only U.S. citizens can petition for their fiance. A permanent resident can file for their spouse to come to the United States, but cannot file for their fiance to come to the United States. You must be a U.S. citizen to petition for your fiance. Another requirement is the in-person meeting requirement. So that means that the petitioner and the beneficiary have to have met within 2 years of filing the fiance petition, which is the I-129F. That meeting could have taken place anywhere in the world. It could have been when the beneficiary visited the United States and they saw each other in person, or it could be when the petitioner visited the beneficiary in their home country and they were together in person, or it could occur in a third country. You just have to make sure that you prove this requirement that there was an in-person meeting within 2 years of filing. Okay, and with a lot of people meeting online, falling in love online, that sometimes can be a difficult requirement to meet. But if you have not met in person within 2 years of filing the petition will be denied. The process is really a two-step process, and I say that to make it simple to wrap your head around and understand, because there is a lot of complication. There's a lot of documents that need to be filed by certain times with certain agencies, but I like to break it down, make it simple. It's a two-step process. First step is the petition that's filed with USCIS, okay? That's where the petitioner is showing that they've met that 2-year in-person requirement, that they're eligible to marry, that they're legally free to marry, that both parties are, and that they intend to marry the beneficiary within 90 days of the beneficiary coming to the United States after their fiancé visa was approved abroad. So that's step one, and I just refer to that as the, I-129F petition or the USCIS part of the process, okay? So I'm gonna refer to the second part of this process as consular processing, and I'm gonna use that as an umbrella to include the many steps that come after approval of the I-129F petition. So after the petition's approved, the approved petition is forwarded to the NVC, the National Visa Center. Certain background checks are done there, and then once the NVC has done what they're doing with the case, they forward it to the U.S. Embassy abroad. And then at the U.S. Embassy abroad, they make sure that all of the documents that they need are in order, and then they go ahead and schedule the case for an interview. So those components, add them together, and that's what I refer to as consular processing, or the second step in the fiancé visa case. It's important to note that for the interview, the U.S. citizen petitioner is not required to go. It's not like an interview in the United States where both the petitioner and beneficiary must be present. In the fiancé visa case, only the beneficiary needs to attend the interview abroad. It's extremely important that all of your documents are in order, that all the right documents have been submitted, that the medical has been completed correctly, that the criminal history clearance has been completed correctly, as any incorrect step in those matters could cause a delay in your case. Assuming that all your documents are in order, the criminal history clearance looks good, the medical looks good, and you do well at the interview, then your case will be approved. At that point, the beneficiary must enter the United States within 6 months of the fiancé visa being issued. Once a beneficiary arrives in the United States, a 90-day clock starts running, and the petitioner and the beneficiary must marry within those 90 days. The fiancé visa is a one-time visa. It's not meant for travel back and forth. Its intention is that the beneficiary, the recipient of the visa, will enter the United States one time and marry the petitioner. That's the purpose, that's its intention. So it's extremely important, if you're going to apply for adjustment of status, that you, it's a requirement that you marry within 90 days. If you want to learn more about adjustment of status, that is beyond this talk about a fiancé visa, but there's plenty of information on my website, www.kwinstonlaw.com. If you have any questions about fiancé visas, you can schedule an in-person consultation or a phone consultation with one of our attorneys. Our phone number is 904-723-4570. Our staff is bilingual, and in the office, this is one of our favorite types of cases to work on, fiancé visas, because it's exciting to learn about how the petitioner and beneficiary met. It's romantic, knowing that they're separated many times by huge distances, until we are fortunate enough to play a small role in bringing the couple together. So it's really a fulfilling type of case for us. We really get into these types of cases, fiancé visas, and it would be our honor to help you and your fiancé be together in the United States through this process. Thank you so much for your time, and be safe out there.